Okay, we're going to talk in details about what is to be studied and what is to be skipped, how smart you're going to be studying, because you're going to appear for the law exam, for which you guys are not the lawyers right now, correct? You have not studied the law. Understand one thing, just the entrance exam, correct? It is just the entrance exam where you will study law for the next 3 years or 5 years, correct? But right now you are not, lawyers. So what they have done is they have given you the middle way. In this is they are mentioning the principles and then they are giving you the facts and thereby they are giving you the four options. So this is the way that you're not yet the lawyers, but they are just interested in knowing what is your interest towards law. Will you actually be able to, cover your 3 years or 5 years of curriculum and be a successful lawyer? So this is what they have started with the entrance exam test, okay? Like they had for years together for, all the engineering and MBAs, but now that they have raised the bar for the lawyers also, okay? So for the law exams also, they have set, entrance exam whereby they're checking, they're testing you, whereby you are, actually able to cope up, you will be able to actually cope up with the law exams or the law curriculum or not. Okay, because you have all the three things to be studied. That is the civil part, correct? The criminal part, and also the drafting part. So all these things will be covered, in your 3 years or 5 years curriculum. So they're testing you. And this is what the entrance exam is all about. So now how they're going to test you guys? How they're going to test you? They're going to test you with the help of the English language. They're going to test you with the quants. Correct? They're going to study, check you with your, GK and the current affairs and the legal part also. Now, this is something, these three topics are something that you have been doing since, years together now. But it's legal. Legal, ye jo bracket hai na, this is something new for you guys. Correct? So, we here at Manoeuvre will help you how to study, correct? What to study, when to start, and what are the smart things you're required to do so that you will, get through the entrance exam in one of the best ways and whereby, you can, achieve your targeted colleges. Okay. So guys, whatever question you are having, keep posting in the chat box, correct? And I will answer to each and every query. Okay. And if anything in between also, you can chat with everyone also so that everybody knows what the question is and accordingly we can move out with the section. Correct? So any questions right now or should I go on to the next slide? Great. Okay. So moving ahead, as I told you in my earlier videos also that we will be discussing each and every topic. Okay, we will be discussing each and every topic. So the first topic what we're going to discuss over here is about the must-do topics. Okay, now these are, what is the importance level of these topics? The importance level of these topics is you cannot attempt, your legal aptitude section without, mastering yourself in these, topics, because these topics will constitute your 60 to 70% of the paper. 60 to 70% of your paper will be from these topics. So guys, these are the most important topics. Now understand one thing, why have they just taken, this Contract Act, Law of Torts, Indian Penal Code, Constitution Law, and Law of Patent? Why they have not taken land laws? Yeah, why they have not taken CRPC, that is the Criminal Procedure Code? Why they have not taken CPC, that is the Civil Procedure Code? Because these are some things that you as a beginners, you as a beginners, you as a freshers will not be able to relate to these topics. Okay. Now, Contract Act is nothing but the day-to-day dealing what you're doing. Like if you're going to a shop and you're buying a thing, so you're paying the money. So this is a kind of a contract. Okay. So Contract Act is something, guys, that when when you're going to read it, when you're going to start with it, you're going to relate to it, and it's going to be very easy for you to reproduce the answers from this. So Contract Act is one of the most dominating part in the your legal aptitude section, guys. कॉन्ट्रैक्ट एक्ट के बगैर आप पेपर नहीं अटेंड करने बैठ सकते. Am I clear about it? Contract act is very, very important, guys. So contract act में what you need to study is all the words like, you know, very good question, Shruti. Shruti has posed a question, and I think many of the students will be having the same query. Shruti is asking me, should we learn the articles or section numbers? Now, for the articles and the section number, now sections are something that you have in your all the acts, that is your contract or in your penal code, and articles you have only in your constitutional law. Okay, so acts, in the acts, we don't need to memorize any of the section number. We don't need to do it. अगर ज़्यादा से ज़्यादा, you know, by chance, you know, अगर क्लैट में कभी कभी पूछते हो लोग, ज्यादा से ज्यादा आ गया तो 1 मार्क का ही आता है, उससे ऊपर नहीं आता है. एंड एमएस लॉ सीटी 3 इयर्स 5 इयर्स में तो सेक्शन नंबर्स पूछते ही नहीं कभी. जैसे व्हाट इज द सेक्शन ऑफ, यू नो, योर से योर कल्पेबल होमिसाइड मर्डर, और व्हाट इज द सेक्शन ऑफ कंसिडरेशन, यू नो, which article, which section defines it. ऐसा कोई भी क्वेश्चन नहीं आता. Of course, yeah, when it comes to constitutional law, you need to know the, you know, freedom, fundamental rights articles. You need to know the directive principles of state policy articles. You need to the, you know, the 51A, that are the fundamental duties, correct? You need to know the emergency articles. Okay, guys, so you need to know certain types of, you know, questions, certain types of articles when it comes to, you know, your constitutional law. Otherwise, rest of the topics, Sophia, am I clear now? Otherwise, rest of the topics, guys, you don't need to, you know, remember the section numbers. Very, very crucial, very, very important is that. Okay, do not remember the section numbers. Okay, very good question, Shruti. I think many of the students will benefit from that. Now, moving ahead, anybody, any other query? Okay. Now, moving ahead, guys. So, as I told you in the Contract Act, guys, you need to, you know, concentrate on every aspect of contract law. That is, what is an offer, what is a proposal, what is an acceptance, correct? What is an agreement, correct? What is an agreement? How it is different from contract? What are the different types of contract? What are the essentials of contract? All these topics are very, very important because इससे में से questions आते हैं. Okay. Other things like, you know, what are void contracts? What are voidable contracts? All these topics are very, very important, guys. ये आपको 100% cover करना है. And if you know, if you're joining my lectures, I explain you everything with thorough, you know, examples. So it is very, very easy for you to understand it. Okay. The next part of the contract is, you know, your bailment act, the pledge. वो सब भी आपको करना है. Okay. All those parts, the bailment, pledge, ये सब topics भी आपको cover करने हैं. Ma'am, I have a doubt of what is the difference between a void and voidable contract. Now, void and voidable contract means, void means what? Void means basically illegal, correct? But when it is a void contract, how it is illegal? Because it is already a contract. The difference between an agreement and a contract is that only the contract is enforceable by law. So, void contract is something, guys, when made, it was absolutely okay. But after that, you know, after, you know, signing the contract, there are some, you know, impossibilities to perform the contract. Like the best example, what I cite over here is the usage of plastic. I mean, overnight they had banned the usage of plastic, correct? So now anybody who was earlier dealing with it, might have come out with the contract. So say if on 31st March, okay, 2018, you know, they had banned the plastic. I'm just giving you a rough date. Okay, they had banned the plastic. But any contract which is made before this 31st will be absolutely valid. Correct, guys? Will be absolutely valid. Agreed or not? Agreed or not? Because उसके पहले तो valid ही था, correct? able to perform? Can there be an intra-state trade, say from the 1st of April for your plastic dealings? Anybody who is manufacturing plastic since ages, correct? So any contract, will he be able to actually serve it after 31st of March 2018? No. If he is doing, then it will become punishable offense, correct? So in these regards, these kind of contracts, when made, when they were signed into, they were actually all okay. But later on, when it came to the performance level, later on it became illegal. Later on it became illegal. Now I'll tell you, I'll give you one more example for that. Now, if you have you have asked your friend that I will buy your car. Okay, so you're gonna say that you give me possession on say 1st of October. Okay, but now before that 1st of October, now he might be driving to some Pune or somewhere else, and that car was parking lot में वो जल गई, it met with an accident. So now there is no subject matter only, correct? There is no subject matter only. So law will not allow any of the parties to take advantage of these kind of situations. So those contracts will be a void contract. Will be a void contract. Am I clear about it? Those kinds of contracts will be a void contract. And what is a voidable contract, guys? Voidable contract is nothing but an optionable contract. It is an optionable contract in the sense, guys, कि जो भी party है, like if a coercion is used, okay, like if you're seeing so many buildings are going into redevelopment, but now there is one one tenant or say one owner who does not want to leave his property, okay, so he is not agreeing with the terms and conditions of the builder. Okay, so he will say, I will not leave my property. अगर आपको redevelopment करना है तो करो. So what the builder will do? He will use some illegal force, okay, on him, and he will make him sign the document forcibly, okay, using your coercion, correct? Using your force, he will make it to sign. At that time, because of the pressure, he is signing it. But later on, guys, he has an option whether to abide by the contract or whether to go to the court of law and ask for some justice. So those kinds of contracts are called voidable contracts. Those kind of contracts are called voidable contracts, whereby one of the aggrieved party, जो aggrieved party, उसको आपको chance है that you can go to the court and ask for the justice. Am I clear about it? So when we're gonna study everything step by step, and it is very, very important for you guys to know the legal terms this way, because एक बात समझो, एग्जामिनेशन हॉल में आपके पास बिल्कुल भी टाइम नहीं होगा कि you will try and understand the definitions mentioned over there. We don't have that much of time, because the lengthy principles, the lengthy facts, and then the 4 options, all this has to be covered in a constrained time. Correct? It has to be covered in a constrained time, guys. So it is very, very important that you get used to with the language, you get used to with the wordings, the terms, and everything before beforehand of your examinations. Am I clear about it? Vineet, I hope the doubt has been solved. Correct? Going ahead with the next one is about your law of torts. Now, what is law of torts, guys? Law of torts is nothing but your Priya, please take care of your mind. Law of tort is nothing but your civil wrong, something that is your civil wrong, whereby law is not giving any remedy. It is for the doctor, for the lawyer, judges to assert it at that very moment. Now I'll tell you a simple example. If you're going, say, to Imagica, okay, you're going to Aqua Imagica, and you happen to slide from up, and you see that there is a hole in your tube, so you met with an accident. So under what law will you go and pursue the court? Yes, Ayush, that's true. So for those activities whereby you don't have any law return, but then still there is something wrong which has happened, and you need to get it rectified, or you need to get some compensation from it. Under which law? under which law you will go and go to the court of law is nothing but your law of tort. Now imagining you have Mr. X. Mr. X has an operation as a cataract operation of the left eye. Okay, of the left eye. Now the doctor on the very day will perform on the right eye. The operation will be performed on the right eye. So imagine the loss, irreparable loss being met by Mr. X. So how will he be, how will he be able to go and, get the compensation? He will be going through, law of torts, guys. Am I clear about this? Am I clear about this, guys? Okay. Anybody, any questions? So law of thoughts is very, very interesting when studied in the correct way. When studied with live examples, it becomes very, very interesting. And one of the most my favorites, and yet even scoring. Law of contract, the first dominating topic, then the law of thoughts is the second dominating topic. And both these topics are really scoring. You can expect at least 8 to 10 marks from these topics, guys. So law of contract or law of torts में से आपको कुछ भी option में नहीं छोड़ना है. You have to do each and every topic which is mentioned, whichever book you're referring, whether it is Manoeuvre or any other book. Please make it sure that you're going through each and every topic. हर एक topic का आपका concept clear है. Very, very important is to clear out your concepts, because everything is going to be principal facts based questions. So how it will go about? Am I clear about it? Next is the Indian Penal Code, guys. Indian Penal Code is like a criminal side completely. The assault, battery, kidnapping, culpable homicide amounting to murder, culpable homicide not amounting to murder. All those questions, your theft, your defamation, everything, all these offenses, it is all about the offenses. Very, very important for you to know. See, now all these offenses are, देखो एक बात समझो, maybe this theft, maybe this defamation, maybe this rape, all is an offense. At the end of the day, everything is wrong only, correct? But why are they being defined differently? कोई भी को बता सकता है. Why have been they defined so differently? I could have ended that way only giving my judgment. Yeah, he has done something wrong. But why have I'm saying that he has done theft? Why am I saying that he has not done the offense of defamation, yeah, nuisance, yeah, trespass? Why do I say these things? At last, everything is wrong only. So what is it? Intensity, yes, intensity, but that will help in what, Shruti? Intensity will help in what? Intensity, yes, very good, Shruti. Yes, that's the correct answer. So, अगर punish करना है, see, if one is a fresher, anybody who has pickpocketed, the very first time, okay, the very first time, then he might be, police might just give him a warning and might just leave him, correct? But anybody who is an habitual offender, or who has been doing it for such a long time, maybe he has done the same crime for the fifth or sixth time of pickpocketing, will he be, left by just giving a warning? Do you guys think that? Correct. We can't leave him just by giving a warning, correct? So this is what, every theft, every wrong has to be defined, and uske basis pe aapko punishment hota hai. So it is very, very important for, each and everyone to define it, okay? And accordingly, they will be punished. Now, anybody wants to ask me anything in the Indian Penal Code? Let's go to the constitutional law then. Constitutional law, guys, is again very, very important topic as we are seeing the current scenario whereby everything is getting changed, right? Article 370 and everything. So constitutional law is very, very important. The most important topics from them, there are the fundamental rights, the directive principles of state policy of fundamental duties, the emergency powers. Okay, these topics are something that are very, very important, guys. Okay, you need to know it. and you need to know the articles of it very well. Okay, articles also are very, very important when it comes to your fundamental rights. Okay, moving ahead with the maxims, we have got lots and lots of maxims. Okay, Mr. Roy has asked me one question. Do we find only principal fact questions, or there are also questions on Indian Constitution, the constitutional law? Do we need to memorize the DPSP or other articles or general questions on politics? Now, Roy, first of all, will be going to the slide which is called as types of questions. So do be there. We'll be discussing that. And for the other part of the question, which is mentioning about do we need to memorize the DPSP? Now, let me put it that way. See, DPSP is a very lengthy topic. So I would advise you to just go through it twice or thrice so you come to know okay, DPSP will comprise of this. But it is it is always beneficiary for you to memorize the fundamental rights. So once you will memorize the fundamental rights, then the rest of the things will be DPSP. Because duties is again something very, very different. So when you're going to read that item, so you'll come to know whether it is a fundamental duty or DPSP. So it is always advisable, guys, to memorize the fundamental rights because they're very limited. Okay, and it becomes very easy to remember it with the articles. Okay, if you go through 3-4 times, it will be very easy for you to memorize it. But DPSP is a very lengthy thing. So DPSP and FD, you both need to. FD is nothing but your fundamental duties. Okay, guys. So DPSP and FD, it is always advisable to just you keep on reading twice or thrice, and you will come to know. But yes, fundamental rights, it has to be memorized because you have the static GK का भी portion cover करेगा. Ma'am, international law is asked. No, international law, please do not go for the international law. Do not go for the, family law also. Questions have never been asked from that side. Okay, those laws have never been asked the questions. Please trust us, do the things what we are telling you and you will come out with flying colors. How to cover legal GK and what is the weightage of it in 5 years? Now, Shruti, for legal GK, you need to update yourself with the latest headlines. The legal news which are making the national news. You got to be in touch with that. So when you're reading your newspaper, you can cover it very easily. So you need to know very famous cases, and that will help you a lot. Correct. And for maxims also, ma'am, should be yes. Intellectual property. Kasan, I'm coming on to the next slide to it, Vinny. So be with me, okay? And for maxims also, when we will start the maxim lecture, I'll let you know what is to be studied, which are important for the examination point of view. There are lots and lots of maxims, but correct maxim करने की जरूरत नहीं. I'll help you with what are the important ones, and you need to only focus on that. Okay, so maxims, you need to keep on reading it. Okay, so the more you're going to read it, the more you're going to feel comfortable with it. And I'll give you the important ones, the list of the important ones, and that will be enough for it. Okay. So contract, law of torts, Indian Penal Code, that is your IPC, the constitutional law and maxims. These are the must-do topics. You cannot enter the legal aptitude section without going through these things because this will cover at least 60 to 70 % of your portion, guys. Am I clear about it? Everybody, please take note of these topics. I don't want you to leave any topic out of this because even in Indian Penal Code, you need to understand what is the difference between assault and battery. Very, very important. Okay, what is culpable homicide amounting to murder? What is culpable homicide not amounting to murder? All those types of questions are very, very important. Now, going ahead here, over here is intellectual property. Can anybody tell me what is intellectual property? What is intellectual property? Can anybody tell me? Correct. Intellectual property is all about trademark, patent, and copyright. Very, very important in the modern world nowadays. Okay, this has gained the international attention. We have international lawyers for these kind of things. So, guys, intellectual property a must-do thing, but weightage it's uska rahega after all those things. Okay, so once you're done with the contract, tort, constitutional, IPC, and medicines, then start with the intellectual property. Okay, now limitation act is something whereby, you know, after you see if you have, you know, suffered a loss 10 years before, can you file a case right now? No, you cannot file a case right now, right? So you have a time limit, a prescribed time limit for everything. A prescribed time limit for everything. Am I correct? If you like, I just tell you the section 138 of, you know, negotiable instrument act. Can anybody tell me what is section 138 of negotiable instrument act? Very, very famous it is. Section 138 of negotiable instrument act. What it is? Come on, guys. You might have heard it so many times. If you're reading newspapers, then also you might have heard it so many times. 138 is nothing but your check bouncing. So अगर आपका check bouncing, you know, if it is in 2015, can you file a case today? Is it possible, guys? Come on, answer me. Correct. We cannot file a case today. Correct. There has to be some limitation. Okay, there has to be some limitation. So it is all about the limitation act, when you can file, when you cannot file, what are the reasons, you know. No, it's only 6 months. 6 months. Okay, next is the Partnership Act 1932. Okay, now over here it is not about profit sharing ratio. The Partnership Act over here is not about the profit sharing ratio, but it is related to contract. When you can allow the new partner, what are the duties of the retiring partner, how you can use the partnership property. Okay, those types of questions are there. You can expect hardly a single question from here. Okay, and a single from here, 2 to 3 questions from intellectual property, and this is limited liability partnership. Can anybody tell me the difference between the normal partnership act and the limitation liability partnership act? The major difference between the two, why a new act has been there when you have already have a partnership act? Vanshika, in which act, under which act partners is limited to the amount of capital invested, under which act? Very good, superb answer. Yes, Vanshika is telling me partnership, partner is limited, the liability of a partner, you know, that you can have mentioned in that. The liability of partner is limited to the capital invested. Yes. Limited liability partnership is all about, you know, the liability is limited to the amount you invest. Okay. And in partnership, you have a personal liability also. So in case if you have any debt, you know, on the company, then it is even your personal property will be get attached. Right? So this is the main difference between LLP. Ask the LLP, you know, they have hardly asked any question. But you know, seeing at the current scenario, the importance of LLP it is emerging very well. So you can expect a single question from here. When you know the Partnership Act, LLP does not take much time because there are hardly, you know, 6 to 7 major differences. So we cover that section also. Okay. So these are the less important topics and these are the must do topics. Okay. So take care of it. So while studying, study smart. Do not give, you know, a lot of importance to these topics unless you have, you know, first finished of these ones. Moving ahead, types of question. Okay, so the types of questions are nothing but your principal facts, okay, which is, you know, famously known, whereby, you know, principle is mentioned, correct, and the facts are mentioned. After that, the MCQs are mentioned, first, second, third, and fourth option. So the paper will comprise, you know, majorly of these types of questions. But the other one is also known as, which is known as assertion and reason. I'll be solving one, so you'll come to know at that time. And then the third type of questions can be from legal terms and maxims. Okay. So these kinds of questions they have, they will cover in your examination. Am I clear about it? Assertion and reason, they may cover, may not cover, but principle and facts to aata hi aata hai. Okay, when it comes to MH law, 3 years and 5 years, very, very important are these things. Anybody, any questions? Should I go ahead? Yes, beneath I have taken one example. We'll go to that slide. Now, the next slide is how to read. Now, given the fact, why have I taken this, slide? Please pay attention over here. Now, what is it? How to read? Why? Because you have very limited time. Correct? You have limited time. That is a wrong answer. Please pay attention over here. You have limited time, and in that time constraint, you need to read everything and answer it with accuracy. Then only you will get your correct mark. I'm sorry, but that is also an incorrect answer. Okay, now see the way I'm reading it. Okay, trespass to land means direct interference with the possession of land without lawful justification. Trespass could be committed either by a person himself entering the land of another person or doing the same through tangible things. Okay, tangible object. Now, guys, if you look into these things, then trespass to land means direct interference with the possession of land without lawful justification. So this is nothing but your definition, guys. Do you all agree with me? This is nothing but your definition, correct? Am I clear? So we all know the definition will never change. So once you come to know that the question is about trespass, if you have to never reread the definitions. Never reread the definition, guys. अगर आपको पता चल गया कि trespass पे है, then done. What is important is the condition after that. So this trespass could be committed either by a person himself entering the land of another person or doing the same through the tangible object. Okay. So ये जो condition है ना, that is more important. So अगर कभी भी आप examination में principle नहीं समझ रहे हैं, so make it a point that you're not wasting your time in rereading the definition. Definition के बाद का जो आपको जो condition है, that is more important for you to understand because वो condition पे आपके option के questions होते हैं. So now what are the facts, guys? A throws some stones upon his neighbors, that is B's premises. So now A has committed trespass. A has not committed trespass as he is not entered B's premises. A has committed nuisance and none of these. Now, if you look smartly over here, the definition is only talking about trespass, correct? It is not mentioned anything about the nuisance. So a nuisance now will never be your answer because they don't know you whether you know nuisance or not because you are not the lawyers yet. This is just your example. Okay, this is just your entrance exam, guys. So nuisance will never be your answer. कैसा होता है अपने reading comprehension में this box is mentioned, correct? So all the answers has to come from this box only. All the answers has to come from this box only. You cannot go out of this box. So in the same way, if they have mentioned about trespass, then nuisance will never ever be your answer. Okay. Now, what is the condition telling me? Condition telling me that trespass could be committed by either by a person himself, entering the land, or another person, or doing the same through some tangible object. So over here, my stone is a tangible object. Do you get my point? My stone is a tangible object. Yes or no? Correct. So now what is the main question? Which of the following derivations is correct? A has committed trespass. Correct. A has not committed trespass. A has committed nuisance or none of the above. What is it? Come on, guys. Now post the answers. How come, Sophia, D is the answer? A is the correct answer. Did you understand, guys, what I want to tell you? So this is the way you need to read properly. But before that, before entering the examination hall, you need to know all these words, all these languages very well. Then only with the help of elimination technique, with the help of other ways, you will be able to come to the correct answer. And trust me, if done in a right way, my students tell me I will, around say, I'll get about 26 to 27 on 100 in legal aptitude section. ये section इतना easy होता है guys, but you need to be very smart because जितने principles and facts ना आपको confuse नहीं करेंगे ना उतने आपको आपके options confuse करेंगे. That is a printed mistake. Okay. Okay, now time management, how you need to do it. Maximum time for MH Law CT students, maximum time will be 1 minute 20 seconds. ये मैं आपको max time बता रही हूँ. But it is always advisable to do it within 1 minute. But yet, if you are, if you have to give 20 seconds more, do give it because it will give you the highest accuracy. ये section की accuracy सबसे ज़्यादा आती है students. Okay, so if studied in a correct way, legal will आपका score boost करके जाएगा. Am I clear about it? Never reread the definition. Please understand these things because definition जो रहेगा ना वो legal language रहेगा जो आपको कभी अगर आपको time मिले तो आप consideration का definition पढ़ के देखो. कभी अगर आपको time मिले तो आप culpable homicide amounting to murder, not amounting to murder. ये सारे जो definitions हैं, they are so lengthy, so confusing, which will not help you anywhere. What is more important is the condition labeled with it. What is the condition और यही condition पे क्या होते हैं आपके facts होते हैं and accordingly you have to answer. Am I clear about it? And one more thing, the most crucial part is the elimination technique. Guys, जैसे मैंने आपको बताया, if the passage is talking about, if the principal is talking about trespass, what is nuisance doing there? Nuisance will never ever be your answer. If it is talking about assault, correct. If it is talking about assault, battery will never be your answer, correct. If it is talking about theft, then extortion will never be your answer. They are close by, but they are not your answers, guys. Am I clear about it? Very, very important is how you manage your time, how you read it, and what is the elimination technique. ये सारी जब techniques आप करोगे ना, तब जाके आपको ना accurate answer आएगा, guys. And very, very important for you is to understand what is the main question which is posed. Main question क्या है जो हम लोग ने पूछा है, आपको समझना compulsory है, guys. It is, it is compulsory for you to attend it. Okay, am I clear about this? Great. Now let's solve some questions. Let's solve some questions. A contract which is duly supported by real and lawful consideration is valid, notwithstanding the fact that the consideration is inadequate. Okay, that the consideration is inadequate. The quantum of consideration is for the parties to decide at the time of making a contract and not for the courts to decide when the contract is sought to be enforced. An agreement to which the consent of the promisor is freely please keep your mics on mute. Okay, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promisor was freely given or not. Okay, now, yeah, I mean that's correct. A agrees to sell his mobile phone worth rupees 20,000 for rupees 100 only to B. A's consent is freely given. Which of the following derivations is correct? Now over here we know that it is from the Contract Act, okay, and particularly from the consideration topic. Now what is consideration? Something in return of the other. Yeah, Ayush, that's correct. Something in return of the other, correct. So over here it is saying that the quantum of the consideration is not the court's purview, it is the individual's purview. So if you have a flat of rupees 3 crores, you are all free to sell it for a crore also. Okay, for single crore. It's not necessarily that you charge in 3 crores. Correct. It is for you to do it, sell it in your way. They only need some consideration. If it is without some consideration, then it will become a gift. Correct. There has to be a consideration. So the quantum of consideration is not there till the time जो quantum है वो आपने free consent से दिया है. There is no force on you. Okay. So this is what it is telling you. So when you already know these kinds of principles well in advance, and you know so आपका कितना easy हो जाएगा. So the same question can be done in just in 30 seconds. Maximum 45 seconds. उससे ज़्यादा ना ये question time नहीं लेता है बच्चों का. Yes, Francis, that's the correct answer. Okay, so what are the options? Which of the following derivations is correct? So there is a contract between A and B. There is no contract between A and B because the consideration is not adequate. There is no contract between A and B because a mobile phone worth rupees 20,000 cannot be sold off for just rupees 100 and none of the above. Then we know the principle is clearly stating that the quantum of the consideration is not at all important. So ये तो मेरा रहेगा ही नहीं. There is no contract between A and B because consideration is not adequate. This also cannot be my answer choice, correct? So there is a contract between A and B. Remember every time, guys, that a social and a legal answer and a religious answer will never be a correct answer choice. These are just the fill-ups. They also have to make 4 options. So these are just the fill-ups. The things which is giving you a straight legal language will always be your legal answer, guys. I mean, in fact, if consent is really not I mean, in the fact, if consent is really not wrong, then it will not be answered. Are you sure I'm not understanding your question? Consent was freely given. It is mentioned, correct? अगर नहीं mention हुआ है, then also लेकिन negative नहीं होना चाहिए. If it was written the consent was not freely given, then the answer could be there could be no contract between A and B. Okay, then the आपके options भी अलग हो जाते. Okay, so Ayush, do not think much even in the examination. Just go by it, Yes, true then Ayush. Okay. The next one, caveat emptor, that is nothing but let the buyer beware. Okay, it is not always the seller, sometimes even the buyer has to beware. Stands for the practical skill and judgment of the buyer in his choice of goods for purchase. It is the business of the buyer to judge for himself that what he buys has its use and worth for him. Once bought, and if the buy is not up to his expectation, then he alone is to be blamed and nobody else. Okay, so here he is saying it is not always the seller's responsibility. Okay, here he is saying it is not always the seller's responsibility. It is even the buyer's responsibility with the maxim that is nothing but your caveat emptor. For the purpose of making uniform for the employees, A bought dark blue colored cloth from B. B did, but did not disclose to the seller, that is B, the specific purpose of the said purchase. When uniforms were prepared and used by the employees, the cloth was found unfit. However, the cloth was fit for a variety of other purposes, such as making caps, boots, and carriage linings, etc. Applying the aforesaid stated principle, and which of the following derivations is correct as regards remedy available to aid in the given situation? Now, guys, it is saying you clearly in the principle that buyer has to beware. Okay, so you have to keep that point in mind and move ahead. A, the buyer would succeed in getting some remedy from B. Okay, A would not succeed in getting remedy. A would succeed in getting refund from B. देखो refund वगैरह तो आ ही नहीं सकता क्योंकि उसकी बात ही नहीं है. They are asking you for remedy. The things which is not mentioned ना will never be your answer. तो refund तो हो ही नहीं सकता. They are asking for remedy only. Correct? So refund वाला तो मैंने ऐसे ही eliminate कर दिया. A would succeed in getting a different variety of cloth from B, but will not get the refund. Can this also be the answer? No, this is also not B. So A would not succeed in getting the remedy from B is the correct answer, as many has already posted. Why? Because the rule says that the buyer has to be aware of it. Okay, so this is nothing but the direct implication of the principle mentioned. Okay, it's a direct implication. Am I clear about it? सबको समझ में आया? Should I move ahead? Yes, great. Now let's solve one from the assertion and reason types question. Freedom of speech is the most important civil liberty of people in a democratic policy. This is an assertion. Okay, so this is a statement. And the reason for the same is the state can regulate free speech in the public interest. Now, four options are both A and R are individually true, and R is the correct explanation of A. Both A and R, that is the assertion and reason, are individually true, but R is not the correct explanation of A. A is true, yeah, A is false. Now, guys, in this statement, what do we need to do whenever it is assertion and reason? First, आपको ये individually देखना होगा कि आपका statement true है कि false है. Okay, individually you need to examine. So freedom of speech is the most important civil liberty in a democratic polity. Yes, it is a freedom of, it is your fundamental right. Okay, so this is a true statement. State can regulate free speech in the interest of public order. Yes, this is also a true statement. Yes, because why? To maintain the decorum, to maintain the peace. If they have some. Now, say if you are, say, you're following one religion, so can you talk ill about other religions? Can you talk ill about other religions, stating that I have a freedom of speech? You cannot. Correct. You need to. We are, unity in diversity. We need to respect all the religions. Correct. So this is what you have a freedom of speech. So, अगर आपको कुछ problem है, you speak out. You have a freedom of speech, but for that you cannot ill-treat others. For that you cannot hurt other people's sentiments. Correct. So this is what it is telling me. Now both the statements are true. Correct. So ये तो मेरे options नहीं रहे हैं. Okay. So sir, it might be somewhere from here now. So when I say my both the statements true, what I'll do is I will apply because and I will reread the sentences together. Okay. Freedom of speech is the most important civil liberty of people in a democratic polity because state can regulate free speech in the interest of public order. You think that the reason is the correct explanation of A? Come on, guys, post the answers. Does the sentence make sense after applying because? Very good, Ayush and Shruti, very good. See, guys, for those who have not understood, I'm explaining again. Freedom of speech is the most important civil liberty of people in a democratic polity because state can regulate free speech in the interest of public order. You think that the freedom of speech is important because state can regulate it? So that cannot be the reason. So what is our correct option? That both A and R are individually true, but R is not the correct explanation of A. R is not the correct explanation of A. So even A is not my answer. Option second is the correct answer choice. So whenever you find both the statements true, you need to apply because. And why you need to apply because? Because here a reason is mentioned. So whenever there is a reason, we need a word because, guys. If you will follow this technique now, you will 100% get an accurate answer. A is not because it is not the correct explanation. Joel, A cannot be the answer. Because when you're reading the statement together, it is not making sense. Okay, guys, I hope that it is clear moving ahead. Now, these are some maxims what we're going to cover. Like it is ab initio. Ab initio means nothing but you're from beginning. Okay, from the beginning. Just I'll tell you, contract with minors. Contract with minors. Avoid ab initio. If you give 5 lakh rupees advance to a minor, stating that you're manufacturing some cameras and you send me. But then if he's not sending you cameras, you will not get your 5 lakh rupees also. Because why? Because the contract with minors are void ab initio. Okay, so court will not help you there. You are not allowed to enter into a contract commonly used referring to the time of a contract, statute, marriage, or deed become legal. The couple was covered ab initio by the health policy. Okay, so ab initio means these are the Latin words. Okay, these are the Latin words. Actori incubit honest probatio on the plaintiff rests the proving. Now, whoever is telling something, the onus of proof will always be on the person saying. So it is always on the plaintiff who is starting. The burden of proof falls to the plaintiff, claimant, or petitioner according to the Roman law. Okay, actus reus. This is one of the most important aspects of the criminal offense. There has to be an actus reus, that is the guilty act. Okay, the guilty act, part of what proves criminal liability. So that is the word is known as actus reus. Ad hoc. Ad hoc is nothing but a Latin term for this. नहीं, ad hoc नहीं होता, ad hoc ही होता है. Generally signifies a solution designed for a specific problem or task, non-generalizable, and not intended to be able to adapt it to other purposes. Okay. Affidavit is something that he sworn by, he oaths on. Okay. Is a formal statement. Now, if you have lost any of the documents, so you make an affidavit that whatever I state over here is true and correct to the best of my knowledge and belief. If anything is reversed to that, then I am liable for the punishment. Okay, so affidavit is nothing but a statement, a formal statement of crime. Okay, it's statement on oath, you can say. Okay, so these are few words which are important, and there are many which we'll be covering in our lectures. Okay. Now, guys, we have mock test also. Very, very important for you to attend the mock test, whereby you will understand the time management, whereby you will understand the types of questions, and जहाँ पे आपका reading speed rapidly बढ़ेगा. Okay, because you have in how much time you are attentive and how much an expert takes the time. जो top करेगा वो student पे कितना time लेता है. Everything is being mentioned over here. So you will come to know, and appearing mocks is one, and analyzing mocks is another thing. Because guys, if you are analyzing it, if you're appearing mock, you're at this level. But when you're analyzing mock, you will go 2-3 ladders up, because you know what mistake you have done, which mistake you have done, and where you have done that, committed that mistake. So rectifying these things are very, very important. So appearing marks तो important है ये, लेकिन उसको rectify करना, उसको समझना कि ये गलत तो क्यों गलत है, so that is very, very crucial, guys. You cannot, these marks are the replicas of the paper. Huh? They're the replicas. So even understanding the system, how you got to do it. Sure, you can contact the admin. I have no idea about that. Okay. So, these are the replicas of the, your DD papers. So I would highly recommend you to appear mocks and analyze it, both parallelly. Appear here and analyze it simultaneously. Am I clear about it? Any questions, guys? Any queries? You should be end the session. Any questions, guys? Yeah, yeah. Okay, guys, take care, study smart, and appear the mocks.